are now recording. Again, thank you everybody for joining us today. We greatly appreciate you for being here, taking time out of your day to join us for this webinar. My name is Caleb Talley. I'm the Director of Marketing and Events at Startup Junkie. For those of you who may not be familiar with our organization, Startup Junkie is a mission-driven organization based here in Northwest Arkansas that exists to empower innovators and entrepreneurs through support, inspiration, and education by providing one-on-one consulting, events, workshops, programs, things just like this that you've signed up for today. And we remove barriers for historically underserved populations by democratizing access to entrepreneurial resources and providing strategic support to any individual seeking to establish or grow their business. And all of those services are provided at absolutely no cost to entrepreneurs or small business owners. You'll never get a bill from us. So we're excited to have you with us today. We're excited for you. I'm excited to introduce you to our presenter today. Presenter is Glenda Caton. She is the owner of Caton Consulting, LLC. She has over 20 years of operations management and human resource experience. Her professional focus is on assisting small business owners in all areas of human resource compliance. She holds an associate's degree in business management and a bachelor's degree in business administration with an emphasis on human resource management. She has created many employee engagement programs, built 2 corporate HR departments, analyzed and implemented new payroll and benefit systems. She's well versed in workers' comp, ADA, and FMLA cases. She's also created and managed wellness programs, written and revised company handbooks, and we are honored to have her with us today. So without further ado, I will turn it over to you, Glenda.
All right, thank you so much, and thanks for having me today. Welcome, everyone. We obviously are going to be talking about HR hot topics, and we're going to be talking or covering employment law from an HR perspective. So with that being said, I do have to go ahead and say that I am not an attorney and I am not giving legal advice. Everything we talk about today is going to be strictly from my as an HR professional, and I've worked closely with many employment law attorneys. So just wanted to throw that out there for you. And so let's just jump right in. So HR is just a big deal, human resources, and I'm so excited. I've seen over the years how it's becoming more and more important to small businesses, and it is such an honor to be able to have the knowledge that I do and then to be able to share it to those that may not have the opportunity to or the budget to bring in a human resources professional and as an employee, which that's one thing we'll be talking about as well here in a few minutes. But the topics we're going to cover today, we're going to talk about hire to retire, the employee life cycle. We're going to talk about independent contractors versus employees. And then we'll cover different sections of laws, like if you only have 1 employee, then this applies to you. If you have 11, 15, 50, then these things are applicable to you and your business. We hopefully will have time at the end to answer questions. This is going to be a very high overview because there's so much content. Literally, our HR Society has made like a 3-day employment law conference over it. So just kind of sit back and relax, and we will answer any questions we can as we work through the material and at the end of the presentation. So let's get started. So we have what we call the employee life cycle. So throughout the life cycle, there are specific employment laws that have to be followed. And so we're going to look at some of the most applicable major laws to assist you in growing your business to excellence through an HR focus. So we start with the attraction. So how do we attract the best candidates that are really going to fit with our culture and drive our mission and our vision? And we move through the recruitment process, onboarding, training and development, retention, and then separation. And hopefully that separation is always going to be a good positive thing. Retires, or someone has you've grown to the point that they're able to take an opportunity somewhere else. So separation doesn't always have to be a negative thing. In a lot of ways, it's going to be a positive thing. So I wanted to start first by distinguishing the difference between independent contractors and employees. This seems to be a big one. And in 2018, the IRS recovered over $3 billion from small businesses due to misclassification between independent contractors and employees. And I know we say, okay, well, we can save money that way. It'll be cheaper to just go ahead. We don't have to offer them benefits. We don't have to pay our portion of the taxes, things like that. But that's a very sticky place to be. And so I want to kind of talk about what the difference is and when you really need to look at, should I go ahead and hire someone? Because what we're looking at is if you get caught for misclassifying an independent contractor, you're looking at $1,000 per worker fine, 20% taxes and penalties on paid wages. And typically when you hire someone, you are going to be paying half of their Medicare and Social Security taxes, but the IRS is going to come after you for the entire portion of that. And the independent contractor is not going to have any responsibility in that. They're going to go after the business because they say it's our responsibility to know the difference. So when you're looking at that, there are three major areas that you want to ask yourself these questions. So behavioral, does the company control what the worker does and how the worker does the job? So a really common example I like to use is an electrician. If you call, if you just have a corporate office and there's something going on with electricity, you call the electrician out or you call a plumber. Those are definitely independent contractors, right? But what if you are a plumbing company or you're an electrical company and all of the people that perform services for you, that's actually the function of the business, right? So if they're most likely they need to be classified as employees as opposed to independent contractors in that case. And they do look at all three of these areas. It's not just one, it's do all three of these apply in the situation. And then financial. So are the business aspects of the worker's job controlled by the payers? So these include such considerations as how the worker is paid. Are they on your payroll? If they're an independent contractor, very bad idea to pay them out through your payroll every week. They really need to be in a situation where they're invoicing you or you've set up a contract to pay so much per month or for the project or whatever it is. And then do you provide them with their tools to do the job? So that's something else too you always want to look at. So are they bringing their tool bag? Are they going to, I go into companies and I take my laptop. If the company is like, here you go, we have your office set up, here's your desk, here's your computer, all of your supplies, then we're walking a very thin line there. And independent contractors, for the most part, and there are always outliers, but they should be providing their own tools to do the job. And then what type of relationship is it? If you are calling someone an independent contractor, they don't need to be offered benefits of any kind through your company because that can make the line, you can cross over that line. And is it like a one-time project or a one-time job? Is it a just something you just need them to come in temporarily and take care of something? Or is this a continual relationship, an ongoing relationship, or you're planning on having them around indefinitely? So if it's the latter of the two cases, then more than likely they're going to be an employee. So I just wanted to overview that really quickly because I see that one pop up a lot. So the next thing I wanted to cover is job descriptions. So some of you may be in a position where you're getting ready to hire your first employee. I have a lot of clients and that's the case. And so we go through the whole, job descriptions and handbooks and policies and procedures and setting up your org chart, things like that. But job descriptions are so important because if you hire someone and then later they're like, well, I'm not able to do that job, and you say, but you signed off on your job description, these are the qualifications and this is what you said you were able to do. So that's why it's so important to have a job description, and you need to have an overview of the position. What is that position really going to look like? Just a short 2 or 3 sentences. And then what are the essential functions of the job? So the essential functions of the job come in to play, and we're going to talk about the Americans with Disabilities Act here in just a few minutes. But it's so important that you have the essential functions. So if you have someone and maybe they have an off work or a personal injury or something like that, that is going to prevent them long term from being able to perform the essential functions of the job. Well, as a business, especially if you're a small business, you can't afford to keep filling that role. And while we always want to act in what we want to protect, the employee or the team member, that's always number one goal. We want to keep them in the best health possible to be able to do their job. but sometimes we get to the point to where they're not able to provide that function, and we're going to have to make some really hard decisions. So make sure those essential functions are on there. Make sure your qualifications are on there. Maybe you want someone with a bachelor's degree, or maybe you don't care, as long as they have the experience to be able to do the job. Fabulous. But make sure you put that on there. ADA statement, basically what that's saying is that that you're agreeing that you're capable of performing the essential functions of the job with or without an accommodation, and that we are equal opportunity employers, and we will accommodate to the extent possible. And then have a signature line. Be sure that you get them to sign off on that job description once you've presented it to them. So that's just an overview of job descriptions. And I will say that I have templates for so many things. I'm happy to discuss and share things to an extent afterwards. So if you have any specific questions, or you're like, hey, I really would like you to list that out or send that to me, I'll be happy to do that for you. So the next thing we want to look at is the application. So you're ready to hire and you put your application out there, right? Well, some of these things may seem very common to you. However, I still see on a lot of the applications when I go in and I do audits for my clients, still asking for the social security number, date of birth, race or ethnicity, citizenship status, do you own a car, any health related questions, and then have you been convicted of a felony in the past 7 years? And I think that one is, we're getting to the point where those are, we're not asking that so much anymore. But the importance of not having a social security number on there is because this is that makes it's a confidential document. You don't want to have your application into your normal personnel file with that protected sensitive information on it, so that you can protect the those filling out the application. Date of birth, you definitely don't want to know how old they are. You can ask, are you at least 18 years of age, or are you at least 21 years of age? You can ask that question if it's pertinent to the position or the company and what it does. Race or ethnicity, I think for that one, that's just common sense. Citizenship status, you can ask, are you legally authorized to work in the US? You cannot ask what is your country of origin, or things like that. And some of these things, again, I know they sound crazy, but I've seen it. Owning a car, the way you need to have that question, because it's like, well, how do I know if they can get to work or not? Well, you can ask, do you have reliable transportation to and from work? Now, if this person's job is to drive and they're providing their own vehicle, then that would be a different application than what you would give to your general population. But you can ask if they have reliable transportation. And the reason for that is because it's proven that there is a disparate impact on certain individuals and certain races, and they typically wouldn't own a car due to poverty and things like that. So we just want to kind of steer away from anything that could make someone feel like they're eliminated or defeated, and they could be a superstar team member, but they didn't get through the door. So sometimes it's not just about legal, it's also about what are we saying when we're trying to attract these candidates, and it all starts at the beginning, right? Health questions, that one's really, really sticky. But definitely don't want to ask those on the application. There may be a time, depending on the industry, depending on the position. You might hear me say a lot when you ask questions, I'll say that depends. But we only want to know that they can perform the essential functions of the job with or without accommodation, okay? Nothing specific. And then criminal background, it's kind of this, first of all, unless it's a position, some companies, due to like federal contracts and state contracts and in different industries, they have to have clear background checks if you're working with children or individuals with disabilities, different things. But I say leave that off of the application and make sure that once you get to that point in the interview process, if that's something that matters, because you do run background checks, you give people the opportunity to disclose. But you can simply ask, are you willing to submit to a criminal background check? And if they say yes, okay, great. And then you can talk about whatever that means. I'm not a fan of blanket policies if they look at every single, situation individually, but That's how you can kind of approach that from the application standpoint. So moving right along into the interviews. Um, Again, don't ask somebody how old they are. You can ask them, are you at least this age, if that's a requirement of the position. One of the race, ethnicity, country of origin, and it's really funny. I'm mentoring an intern, and she is from Jamaica. And when I was interviewing her for the internship, y'all, I was in love with her accent. Like I was just captivated. I don't even know if I really even asked her many questions because in my mind I kept saying, I want to know where she's from, just because of a positive thing. But you don't want to ask those things in an interview because that could, if they don't get hired, they could come back and say, well, I wasn't hired because of my race. And yes, they did ask me that question. Marital or family status is a big no. You just need to know that the people have the availability to do the job. And if someone's married, sometimes companies will think that's a really great thing. It shows stability. And then some will think, oh, no, well, if you're not married, you won't be free to travel and do the job. And so by eliminating that candidate, that could also put you at risk for some exposure to a lawsuit down the road. Sexual orientation, religious affiliation. I mean, I think those are just pretty common sense. That has nothing to do with someone's ability to perform the functions of the job. Health questions, again, I just said it 5 times, right? Are you able to perform the essential functions of the job with or without accommodation? Now, somebody says, I will need an accommodation, and they open that up, then just make sure that any discussion that happens is purely in the sense of, okay, let's see what we can do to accommodate you. Now, and then you would be required as an employer, as long as it doesn't cause an undue hardship on you, like if someone is in a wheelchair and you have a very small business and they're going to need an elevator to get up to the second floor to their office. Well, you wouldn't be responsible as an employer to put that elevator in, right? That would be an undue hardship. But what if it was something as simple as someone needing a talk to text mechanism for their computer? I mean, just simple things like that. So you can weed through those things. Use of illegal drugs, absolutely not, especially right now in Arkansas when we have, medical marijuana. So with the drug, you can ask if they are willing to submit to a drug screen because that's your consistent company practice. But you can't look at someone and be like, I think we might need to drug test that one or not that one or whatever. So keep away from that. And then prior arrest. It does not matter how many arrests people have from a legal standpoint. It does not matter how many arrests someone has had, how many charges they've had. Again, disparate impact on, especially on Black and brown men and boys between the ages of 18 to 25. So you want to stay away from the arrest. Now, are there actual convictions? Okay, and then look, if that is the case, number one, give them the opportunity to disclose that when you say, are you willing to submit to a background check? That kind of opens that up for them. And then you can look at, their return and just kind of look at each situation individually. So unless, again, you have contractors, it's federally mandated that, individuals, have a clean record for so many years or whatever. But just make sure you understand the difference between a conviction and a charge. Okay, convictions, you can utilize that. Charges, you got to pretend like you never saw them if they come back on the background check. So that's kind of our our recruiting to hiring piece, right? So now let's say we've got our employees in here. And here we go. I think that we have a very diverse audience today as far as new employers all the way up to some that have a large workforce at this point. So I wanted to cover as much as I could and start with, if you have one employee, then you are subject or you're guided by 54 employment laws. Now, not all of those are pertinent to HR. Some are more considered, like for financial and different areas that you are probably more aware of because throughout history, they've been more prevalent than our HR is. But there are many, many laws that apply to you, even if you have a small workforce. So I wanted to run through those real quick. So if you are an employer with even one employee, and that's going to count you if you're running through your payroll, and you're your only employee, okay? So we're required to keep personnel records on file to include name, address, phone number, social security number, date of hire, date of termination, all timekeeping and payroll records, to include federal and state withholding documents. Plus, there's a separate place that we're going to keep an I-9, but we'll talk about that when we get to that regulatory agency. And of course, you want to keep them all in a nice, secure place where not just anybody has access to them. You want a person's information. And there are record keeping requirements as far as retention is concerned. So you want to keep your personnel files like, oh, well, they don't work here anymore, I'm just going to pitch that out. Well, no, because you need to have them on file for at least a year after date of termination or 3 years after the date of hire. So whichever one is longer, that's how long you're going to need to keep that paperwork. And then I believe with the timekeeping and payroll, they have a separate set of standards as far as the IRS is concerned. But we typically go with the 7-year rule on that one, so that if anything comes back an audit or whatever financially, you can have those records to show. The Immigration Reform and Control Act. So that's the one with the I-9. So this is one of the things, and y'all, if y'all are in Northwest Arkansas, you have an amazing resource up there. Sheila Mossa, I-9 lady. I absolutely love her, and I've learned so much from her. But we're only allowed to employ those that are authorized to work in the U.S. That does not mean that somebody has to be a U.S. citizen. That just means they have to be authorized. So when we complete the I-9 form, which I do hear from clients a lot, they're like, yeah, I have my application and I have my tax withholding forms. That's all my CPA said I had to have. Well, that's all the CPA needs. What we need, in addition to these other things that we pointed out, is an I-9 that's properly filled out, because one mistake on an I-9, like putting a dash instead of a slash, can cost you like a $240 fine. And that's for everyone that they find on that form. So it's very important that when you utilize your I-9s, that you get the most updated version and you follow those instructions exactly. And then you keep them in a completely separate place from the personnel file. Okay, so if you get an ICE audit, they're not allowed to see what you have over here in the person's personnel record. And if you get a Department of Labor audit, they only are allowed to see the personnel record. They're not allowed to see. Their concern isn't whether the person's a U.S. citizen or not, or authorized to work in the U.S. Their concern is, are you following our Department of Labor guidelines? So you want to keep those separate and keep those things confidential. The FLSA governs basically how we pay, when we pay, who we pay, child labor breaks, things like that. And actually there is no like actual break rule. So some people are like, well, if I work 6 hours, then I'm entitled to a 30-minute break. Well, not necessarily. Now, if that's the company policy, great. But the FLSA, they don't have a lot of regulation around that, and neither does the state of Arkansas. So, and I will say we're really lucky to be employers in the state of Arkansas, because it's easier to follow all these guidelines, because ours closely mirror federal standard guidelines. And so that makes it just a little bit easier that we don't have to look at, so many, like if California, even Tennessee, there are so many other ins and outs. It just makes it a lot more difficult. But anyway, so that was a sidebar. So then we have the, okay, so all employers are required to withhold federal income tax unless they qualify for an exemption, okay? So make very sure that if you're doing your own books, then you're withholding and filing the right amount of taxes. Federal Insurance Contribution Act, so that's FICA. You hear like people saying, what in the world is FICA and why are they taking my money, right? So that's your Social Security and Medicare tax that we talked about a few minutes ago, when I said if the IRS audits you and finds there's a misclassification, typically the percentage is 15.3%. And when someone's an employee, you're withholding half of that from their paycheck and paying the other half. So make sure that that's happening. Then we have our Equal Pay Act. and the Paycheck Fairness Act, and that's really exactly what it says it is. It's equal pay for equal work for men and women. So looking at various surveys, it's kind of a large gap, but we're still showing that even today in 2021, that men are more likely to make 2 to 20% more than a female, given everything else is comparable across the board. So when you're looking at your comp strategies or how you want to pay, then we just want to make sure that we're comparing apples to apples and look at education, experience, skill set, and things like that. So if you have someone with, I don't know, a master's degree coming straight out of college, but they have no work experience, let's say a female coming out of college with that degree and no work experience, well, there you would be able to justify paying her less if the other person working in that or the same or a similar position had, a bachelor's degree and 20 years of experience in that exact position and things like that. So that's fair, but what's not fair is when you have two people that are comparable and they're getting paid different wages. So just watch that when you set up your comp strategy. And then workers' comp in Arkansas, if you have at least 3 employees, you are required to carry workers' comp. That is a benefit that you are 100% liable for paying, and it's for any workplace injury. If you have, if you're in specific industries, I believe construction is one of them, and there are many more, then you might also be required to carry workers' comp, so you can get with your insurance agent or call the Workers' Comp Commission. They've been so very helpful, and just if you have a question and talk through whether you should be carrying workers' comp or not. And this is another one where misclassification between independent contractor and employee is concerned. I had a situation where I was internal HR and I was new to the company, and someone that was off, I was corporate, right? So this was at a completely different property, wasn't even aware that this person was working for us, and he fell off some scaffolding and hit his head and passed away. And after, when that got turned into me, then it created a huge, we went back and looked at everything, and I immediately said he should have been an employee all day long, but doing what I can't, so I've still got to do this investigation. Well, when workers' comp got involved and OSHA even got involved, then they both said this was an employee. It doesn't matter that the employee preferred to be called an independent contractor. It doesn't matter what the company, what their agreement was. OSHA and workers' comp both said that person has been misclassified, and we're going to cover them as though they were an employee. So another time when that comes in to be very important, right? So some more with just one employee. So the Arkansas Civil Rights Act of 1993, it makes it illegal for an employer to discriminate because of race, religion, national origin, gender, or the presence of any sensory, mental, or physical disability. It covers employees who work for employers with less than 15 employees, which, by the way, is with the Americans with Disabilities Act. They start at 15 employees, okay? So in Arkansas, it's from the word go, from the first employee on, right? So just make sure that you are familiar with those guidelines and that you are adhering to those. And then we have the National Labor Relations Act. We just got a new chairperson sworn in last week, I think. So it's interesting to see how things are going to kind of shift a little bit. But it allows employees to join a labor union, and it's also the one where it says if someone wants to go on Facebook, or someone is out in the area with the rest of the employees and they say, we feel like this is an unsafe workplace, or we feel like, things like that, then that's protected concerted activity. So they cannot be disciplined for that. So that's just another area that the NLRA covers. And then we have the Consumer Credit Protection Act. And that's basically, I think, for the main purpose, unless you run background checks, and then there's so much more to be poured into that. But that's the one where we're looking at withholding. So if someone has a garnishment or child support, things like that, then we are required to comply with that order. Generally speaking, most of the time, I think that you can't withhold more than 25%. So if you have somebody that, true story, has like 8 kids by 6 different people, then you can't withhold their entire paycheck, right? So I think up to 25% after tax is what you're allowed to take. And then we have the Employee Polygraph Protection Act. This allows lie detector tests. We have HIPAA. Everybody should be familiar with HIPAA. It's thrown around a lot, even in places that it doesn't apply. But as far as from an employer standpoint, employee medical information, doctor's notes, health plan enrollment forms, that's something a lot of people don't think about. They all must be maintained in a separate file from the personnel file. So again, a lot of times I'll go in and do audits of personnel files and I'm pulling doctor's notes out of the file. I'm like, no, this can't be here, because if you shared that file with the Department of Labor, guess what? They now have information on someone's medical history or maybe someone's medical issues. So just make very sure when you have a workers' comp injury and you're keeping those records, those are kept separate. If you're doing an ADA accommodation, going through the interactive process, that's going to be kept separately as well. Those do not go in the main personnel files. And then we have ERISA, which requires full disclosure of retirement, pension, and health-related plans, such as long-term and short-term disability life insurance. Basically, it says you're not going to discriminate. You're going to offer benefits consistently to everyone. There's some caveats in special cases, but for the most part, that's what that regulates. And then, of course, we have OSHA. All employers are required to provide a safe workplace free from known hazards. So that's important, because we want to make sure, like if you have outlets that aren't covered, or you have slippery floors and there's no wet floor sign, or there are any known hazards, you're not providing protective work equipment for people, like if they're a welder and you're not giving them the goggles that they need to protect their eyes, or the face mask, things like that. So if there's a known hazard in your workplace, it is your responsibility to protect your workers from those things. Speaking of OSHA, so we'll jump up to if you have 11 employees, so 1 to 10, those are the things that we're covered, right? And then we hit 11 employees. So typically if an employer has 10 employees, you're required to keep your OSHA logs. Those are 300 and 300A, and then 301 for posting purposes. So that one really matters. If you have 20 to 249 employees, you must report your incidents electronically each year and post the information in a conspicuous place, typically a break room, something like that, where employees can see it. And it has to be posted from February the 1st through April the 30th. And you can get more information from the OSHA website. At the end of the presentation, I've included several links. So if you wanted to dive deeper into some of these topics and you prefer to do the research on your own, these websites are typically pretty easy to navigate when you know what you're looking for. So then we have 15 employees. That's where our ADA, the Americans with Disability Act, comes into play. So it says you must make reasonable accommodations throughout the entire life cycle. So if someone needs an application in large print because they have a visual disability or just different things, but you are saying that you're going to, from hire to retire, if they have a disability or they acquire a disability throughout their time of employment with you, then anytime somebody says, I mean, even something as we have the Pregnancy Discrimination Act too, but someone says, I'm pregnant. Okay, well, that triggers that we're going to have the ADA interactive process or conversation at some point. If someone says, I've been diagnosed with cancer, or anything, then just train yourself and train your managers and supervisors when they hear someone say anything that has to do with a possible health condition, that triggers, we've got to have an ADA interactive process. Then genetic non-discrimination information. You can't withhold job offers nor health-related benefits due to family history of disease or other health conditions. We have Title VII, the Civil Rights Act of 1991, and thankfully, well, it's 1964 and then 1991, and thankfully throughout the years we've had many revisions and additions to this act, which I think is 100% a positive thing, but it covers employers with 15 or more employees. In Arkansas, it starts at 4. It prevents discrimination based upon color, race, national origin, religion, sex, disparate impact, which we spoke about, and it includes expansion of the ADA and then the Age Discrimination and Employment Act, which is our next. And there are others now that have been added, sexual orientation. Yes. Okay. So sorry, I lost my train of thought. So, but then we move on to the ADA, which it has been expanded to include, and that's basically discrimination against anyone over the age of 40. So you cannot refuse to hire someone. You can't fire someone based upon age alone. Okay, if they are over the age of 40 years. And then we have COBRA. I think the hot topic right now is with the American Relief Act that just got signed a couple of weeks ago. There are tax credits being offered to employers to help with COBRA in certain situations, because your health plan may be $200 a month when you are within the company, and then you leave the company. Well, then it's going to jump up to $600 or $700 a month because you're now responsible for the full premium. And what they're trying to do, and that covers if you have more than 20 employees. Sorry. So what they're trying to do is assist employers in being able to keep people with allow them to keep their health insurance, basically. Sorry. So if 20 or more employees, you have to offer them COBRA, and you have to mail that notice out within 30 days from the time that they leave your employment. So jumping to 50 employees, we have the ACA. This is kind of an exciting time, depending on how you define exciting. And I say that because every time the party changes in the White House, we see a shift. Employers, companies, we see a shift in so many things, dealing with managing our business and managing our workforce. So it's going to be interesting to see how the ACA plays out, and as Biden continues to push on that issue. But basically, it requires affordable health coverage to be offered to 95% of your full-time employees if you have 50 or more employees. Now, that may mean that you have 100 part-time employees. Okay, well, that's going to put you at that 50 employee status. Okay. Then we have FMLA. So FMLA allows an employee 12 months off, but they have to have worked 1,250 hours within the last, they have 12 weeks of leave time, unpaid, and they have to have worked 12 months and 1,250 hours in order to qualify. And the FMLA allows them to take care of their own medical condition, as well as be the caregiver for a family member's condition, or to adopt a baby, spend time child bonding or parent and child bonding, things like that. The difference in the FMLA and the ADA is only for your medical condition. It doesn't cover you being the caretaker of someone else due to their medical condition. So the FMLA does allow that. And that's a whole process. So if you have not had to offer, or you have not been offering, but you're covered under the Family and Medical Leave Act, then that's something we can look at, and I'll be happy to help you navigate that if necessary. And then we have affirmative action plan. It requires all government contracts with $50,000 or more in contract to have an AAP in place. And that affirmative action plan is basically saying that you are targeting certain protected classes in your hiring efforts, as well as in your retaining of employees efforts. And so you have that. And, as we're starting to draw near the end, I'm like, but wait, there's more. So on top of the AAP, like I'm not the one you'd reach out to from an affirmative action plan. That's not my area. I know enough to be dangerous. But I reach out to my friend that does, that his company specializes in that. And I'm always like, I need an AAP, and we have to file our EEO-1s, and we have the VETS 4212 that hasn't been filed. And he's like, wait a minute, those are all different things. So there is a difference, but if you have the 50,000 in government or federal contracts, then you have to have an affirmative action plan in place, right? Okay, so if you have 50 or more employers and you have 50,000 in contracts, you must file an EEO-1 report. That's basically giving them the demographics of your workforce. And then all federal contractors with $100,000 or more in contracts, you must file a VETS 4212, and that's basically a report of how many veterans are working within your organization. But then all employers, whether you're a federal contractor or not, you are required to file that EO1 report with the EEOC, and they didn't take it last year, and they just announced a couple of weeks ago that they are requiring 2019 and 2020 reports to be filed. And that the portal for filing, because you file it electronically, so the portal for filing through the EEOC opens on April the 1st, and the rumor on the street says they're not going to leave it open for us for very long. So if you have not been doing this and you feel like you may qualify in one of these areas, then we need to get you started on getting your report gathered, because I want you to feel happy and stuff, but it's a nightmare, just to put it out there for you. And then, of course, we're in the pandemic. I get so many questions from so many clients and just random people on Facebook or email or text, and they're like, hey, what is this about? So back when the CARES Act was introduced in the FFCRA, it was requiring any business with less than 500 employers to offer emergency paid sick leave, and emergency paid FMLA. So, and then what they were saying is, well, if you, due to a COVID related reason, right? So if your employee gets sick or they get exposed or they have to take care of a child because school closed down, different things like that. So the IRS is giving you a dollar for dollar match on everything you paid out to that employee. So that way it's not hitting the companies as hard, because a lot of companies that have not had to offer FMLA, all of a sudden, not only are they having to offer FMLA, but they're having to pay, a portion of the salary. And that hurts when you are on a very tight budget and you're a smaller company. So that is something they did to help us, and they mandated that you give that leave. Well, when come January 1, the act expired, and so they renewed it, but with some tweaks. They said, okay, you're no longer required to offer this leave, but if you want to continue to offer this leave, then we'll still give you that tax credit on your payroll taxes, a dollar for dollar match. So now we have the Americans Rescue Plan Act that was just signed into law a few weeks ago, and it extends the tax credits. They were going to expire at the end of March, but now it extends those tax credits until September the 30th. And you don't have to pay people any longer. Okay, so if you want to give them leave unpaid, you can now do that. If you want to give them COVID related leave and pay them for that, then you can still claim a dollar for dollar tax credit. So it's really kind of setting you up for being a good employer. It's gonna cost a little bit on the front end, but it'll come back to you on the back end. You want to make sure, well, let me skip down a little bit. So with the American Rescue Plan Act, it also expanded the FFCRA guidelines. So you can grant someone paid leave if they are going to obtain the COVID-19 vaccine, if they're recovering from any illness or condition related to the COVID vaccine. I think we've all seen people who have had COVID and then they're still struggling with other areas. It turned into pneumonia or a different, it's all over the place. It's crazy. So that's now covered. And then seeking or awaiting the results of a COVID-19 diagnosis or test if either the employee has been exposed to COVID or employer requested the test or diagnosis. So if you send them, now you can give them the paid leave and you can claim that tax credit. You want to make very sure your leave policies are updated and they're consistent across the board to include specifically whether COVID related leave is going to be paid or not. You just want to be consistent. And here's the biggest question I get all the time. Can my employer require me to take the COVID vaccine? The very short answer is yes. Yes, they can. And then you have to make the decision. If you're anti-vaccine, you have to make the decision whether you want to work there or not. There are some conditions, if you have a medical condition where your doctor has advised that you don't get the vaccine, or there's a big lawsuit right now and I'm waiting to see how it plays out. But a healthcare worker, she was required to get the vaccine, and she's pregnant, and she said, I don't know the effects it's going to have on my baby right now, so I'm not getting it. So there is now, she filed an ADA claim to kind of, I mean, she lost her job, she couldn't work there anymore, right? So we'll see how that goes. And then yes, you can, as long as you are applying it consistently, you can ask people to give proof of the COVID vaccine if you are requiring them, or if you want to know like who has been vaccinated for a purpose that pertains to the business itself, not just because you're curious or you're going to use it later to discriminate against them, but it's just kind of like if you require proof of a TB skin test, or if you're a DOT driver, and you have to have your medical card, things like that. So the short answer to those two biggest questions that have come around lately is yes. There are always outliers, though. That's the thing about what we do when we're managing employees. There's always going to be something. So, and then if you were giving paid leave, and before it was emergency sick paid leave, you got 10 days where you were paid like full compensation for being out, and then it switched over to the employer or the emergency FMLA, and then it only paid a percentage or a smaller amount. Well, if someone utilized their 10 days of their 10-day sick leave cap, then now with the American Rescue Plan Act, it says that we've reset their 10 days. So they can utilize another 10 days of paid leave between April the 1st and September the 30th, even if they've already used that 10 days previously, like back in 2020. So that is really, those are the biggest things that I have, but I wanted you to know, I mean, there's so many resources. And again, I mean, I'm like one of those, if I have an accounting question, I'd rather just call and let an accountant handle it, or a marketing question, utilizing the Startup Junkie to help me with my marketing and business plan and things like that. But some people love to go and do their own research. I have clients tell me all the time, I Googled that, and you don't Google HR and you don't Google health questions. So I wanted to give you some specific resources that you can turn to if you are one of those that likes to do your own research. Obviously, the Startup Junkie brought us all here together today. So that they are definitely an amazing resource. Then the Federal Department of Labor, the Arkansas Department of Labor, they have small business sections to help specifically you. Obviously, OSHA, Arkansas, Occupational Safety and Health. The EEOC, you can call the Small Business Administration. We have an amazing human resources state, well, it's called Society of Human Resource Managers. We have an amazing state, and we have some amazing local chapters as well. So those could be good resources for you to get information. We post things on, Facebook and on our website. And then of course you can always reach out to me. This is what I do. So, and I wanted to let you know, these agencies all have hotlines where you can call. You don't have to tell them who you are, what company it is. You can simply tell them, I have this question, and they will get you to the department or the person that needs to help you with that. So you don't have to be afraid to call them. It's a great resource. Even the IRS has a legal department for employers. Department of Labor has a great resource, OSHA. So, okay, with that, I am done. I hope that I have helped you to empower your small business to achieve excellence with a focus on human resources. And I am open for questions if that's okay with Caleb and Morgan.
Absolutely. Thank you so much for that presentation. That was fantastic. Very informative. I'm going to give everybody the opportunity. If you want to drop your question in the chat, feel free. We'll read it out loud. If you want to unmute yourself and ask your question out loud, that's great too. If you're watching on Facebook Live, drop it in the comments. We'll read it from Facebook Live. Feel free to ask away.
Hey, while we're waiting for some people to put comments in, I will ask a question, which was recently asked to me, and I didn't really know the answer, so I'm gonna just pass it along. Can an employer who is seeking to diversify their workforce preferentially hire an individual of color if that is not necessarily the best candidate for the position, and or they do not necessarily have the qualifications required for the position or preferred qualifications even, but the employer would train them into that position.
Yeah, as long as you're not discriminating against the protected class, then you're okay. I would say I would be more concerned about the fact, and like I'm big on diversity, equity, and inclusion. I'm all about it, but I'm also big on making sure we have the right person in the right spot. So I would question now if you can have a great training program, absolutely bring them in if you feel like culturally they fit because their personality fits with the team or they're going to bring a lot to the team, and that they have the basic knowledge to be able to be successful in that training. And I say that for everybody across the board. Then yeah, go for it. I wouldn't advertise that I'm looking for, someone of color or someone, under the age of 35 or someone of, like just be careful. But there are recruiting tactics you can use to make people feel more comfortable in applying at your organization. And I think that's really the standpoint you need to go from is try to, one bite at a time. Like what does your website look like? Is it friendly for people across the board? Just quick story. When I first had my website done, I was sent the flip book and I was looking and I was like, okay, I don't even identify with this. It was a bunch of, and no offense toward anyone, but it was a bunch of middle-aged white men sitting around a board table. And I'm like, this isn't me. So we've got to go back to the drawing board on that. I would not have felt comfortable doing business with me because you're only taking care of those people in your pictures. So I think that's a better way to go about it.
Yeah, that's a great recommendation. Thank you.
And we have a comment in the chat, or a question in the chat from Leslie. She asked, can an employee decline getting the COVID vaccine for religious reasons?
I don't think we've really talked about that. I don't think we've seen much guidance on that. And maybe if you have, then let me know. I think it's strictly an ADA thing at this point. I could be wrong on that one. I haven't read a lot about it. Morgan, do you know?
Well, no, I don't know. But I think that it's sort of, they can decline the vaccine, but an employer can still require it. And so at that juncture, it sort of becomes the employee's decision to not work there if that's a condition of the job.
Yeah, well, and I think that also speaks to if, so like when I said that if you have a health reason for not getting the vaccine, then the employer can, if it's possible, they can put you in an area where you won't be exposed to others, like as an accommodation, and they should try to do that. Yeah. But if there's no workaround, I would definitely get legal advice on this one, but if there's no workaround, then they don't have to accommodate you. They don't have to build you your own separate building to, work within or, things like that.
Yes.
That's a good question.
Yeah,
that was. Thanks.
It's I mean, these COVID questions are kind of evergreen. Like there's new policies coming out all the time, and also we don't know. There's a lot. Nobody knows. There hasn't been like a precedent set yet, or that hasn't been determined, and or there hasn't been a lawsuit yet that's created a ruling, and so yeah. So
the good news is the EEOC is getting ready to send us some guidance, to send employers some guidance on how to navigate without discriminating. So I'm ready for that to come out. I think that'll be very helpful.
Yeah. This has all been so fabulous, Glenda. I remember when I started working in HR, I would have really loved this presentation. I'm glad I know you now. Oh, we've got another question here in the chat. So Cynthia is asking, sorry, Caleb, I'm just jumping in here. Okay. Cynthia's asking, she works in home care. Can she require employees to get their COVID shot since clients are immune compromised and in an older generation?
Yes, you can. Yes. As long as it's a consistent practice across the board, you can make that a company policy and a condition of employment.
Consistency is key. That is, you want to definitely be an employer that has your bases covered in treating everyone the same and having the same requirements, or like you were saying, basis for certain pay levels or time off policies or things like that. If it varies, it should still be consistent.
Yeah, yeah. Isn't it funny? We're supposed to, like, our entire mode of operation should be consistency, but then we've got like all of our governing agencies like with no consistency. Like, so we're just gonna like drop. And then humans in general are not consistent. We don't all have the same behavior.
Yeah.
And so every situation really is unique.
It's so true. We're not consistent, and we also aren't very change tolerant, which those two things seem to be contradictory, but they happen at the same time.
That's awesome.
I don't see any questions on the Facebook right now. So if you're watching on Facebook Live, you're more than welcome to drop a question in the comment too. And just to give everybody a heads up that's viewing right now, we will distribute a link to this video. We'll upload it to our YouTube and distribute that out to you as well with the slides, which has Glenda's contact information too, if you have a question that you don't necessarily want to ask in the arena.
Yeah, I was sure that you were going to be blown up with questions on here, Glenda, but then upon further reflection, HR related questions tend to be a little sensitive and maybe, more confidential.
Right.
We've got a question here. What is your Facebook page and how often do you go live? Do you cover different topics? If that's for Startup Junkie, I can throw our link for our Facebook page up in the chat, and we go live all the time and cover all sorts of different topics related to startups and small businesses and entrepreneurship and things like that. If that's a consulting question, Glenda, I'll let you take it.
Okay. Yes, I do have, it's Caton Consulting LLC on Facebook, and I also have LinkedIn, but I'm super excited, and I don't know how we would share this with you. Maybe I can pass it on to Morgan, but I'm going to be partnering with another HR professional, and we're going to start a podcast called HRER, like employee relations, but still everything that goes on in HR is an emergency, right? So super excited.
So clever. I love it.
So as of last week, I have a YouTube channel now. So, so we will be starting on Sunday. I'm sitting down to start recording. So, and there'll just be short clips. It's not going to be, you don't have to sit, for hours and listen, like 3 to 5 minute things that have come.
I dropped that link to your Facebook page in the chat as well as ours.
That is brilliant. HRER. I've thought about starting a podcast called HR Horror Stories, but yours sounds a lot more constructive and useful. Awesome.
That's so funny.
Right. Well, if we have no other questions, we will go ahead and conclude. Glenda, thank you times 1,000 for being willing to come in and present for us today. And I know we talked about doing this as a a series, and I love that. We can talk about some other incredible topics we can look forward to in the future. And I want to thank everybody for taking time out of their day or their lunch hour to tune in and participate and ask questions. And we hope to see you at the next event.
Awesome. Thank you all so very much. Thank you, Startup Junkie.
Y'all have a great day.
Thank you, Glenda.